Good evening, everybody. Welcome today in this wonderful venue here at UNSW as we have a bit of a conversation around legislation, policy, and governance. So, to get us going, what I'm going to do is I'm going to ask each of Alastair McEwin, Lainey Feingold, and Rosemary Kayess to introduce themselves to you and provide you a bit of background of who they are and maybe why they're on this panel with us. So with that in mind, I'm going to pass to Alastair to start.
Thank you, Stuart, and good evening, everyone. It's a great honour and privilege to be here. I too acknowledge that we are meeting on the land of the Gadigal people. I pay my respect to their elders past and present, and I pay my respect to Aboriginal people who are present here today. My role as Australia's Disability Discrimination Commissioner is to ensure that people with disability, no matter where they live in Australia, have their human rights completely fulfilled on an equal basis to anyone else in the community. And given the rapid development of technology to the point where many in the community take technology for granted, we're also seeing, in my view, a widening divide between the technical have and the technical don't have. And by that I mean people with disabilities are being excluded from often the most basic forms of technology that so many others take for granted. In Australia, we have a framework of discrimination laws and the human rights framework, particularly through the Convention on the Rights of Persons with Disabilities. So we have a framework. However, what we are seeing is a lack of practical implementation and uptake by government, service providers, and the wider community in ensuring that any form of technology is accessible for anyone to use. What I hear every day from my colleagues and friends with disabilities is that they are frustrated. They are particularly frustrated at the lack of not being consulted and being included at the beginning of the design process for technology. To me, that says we have much to improve. We need to ensure that developers and organisations don't just assume they know what's best. For years, we've had what I would call a charity model for people with disabilities, where they are just expected to be able to use what they are given, rather than being at the centre of the design. So we do have much to do. We do also have many opportunities. Technology has enabled many people with disabilities to lead very independent and meaningful lives. The challenge for us here in Australia is to make sure that anyone, irrespective of their disability, can use any form of technology. Thank you.
Thank you very much, Alastair. Lainey, who's come all this way from San Francisco in the United States, so she's been here for a few days now. Lainey, why don't you introduce yourself? I'm not sure everyone knows who you are. There are obviously some people here who definitely know who you are, but give us a bit of your background.
Okay, well, first of all, thank you so much for having me and for coming, and it's really great to be here. I'm Lainey Feingold. Stuart said, why are you here? And I think I'm here because accessibility is global, and the disability community is global, and we have so much to learn from each other and share with each other. One little thing is that when I was here last year in Sydney, and you did the welcome to country, I said, wow, that's a good idea. We don't do that in the US, and I do it in every presentation that I do, and I even do it in the webinars, and it's gotten such a great response. And I say, I learned that in Australia. And, we have Native people in America too that don't get acknowledged, so I want to thank you for teaching that. I'm a disability rights lawyer, and I've worked with the blind community in the United States since 1995. On various technology issues. I started with talking ATMs, and I've worked on accessible websites and mobile app, accessible pedestrian signals, talking prescription labels, and I do all that in a collaborative process that I've developed along with the members of the blind community I work with. We call it structured negotiation, and basically for the short version of it is that it's just a way to bring people into the room and solve problems using a strong legal foundation There's really two parts, like Alastair said. There's the framework and there's implementation. And in the US, we have a strong foundation, we have a strong framework, and I've been really lucky to be able to work with disabled people based on that foundation in a collaborative way, which puts disabled people front and center, which many law processes don't. So that's what I do, and I wrote a book about it, and it's just been great being able to share it with people in the US and people around the globe, and I feel very welcomed and friendly with Australia, so thank you all.
Thank you very much, Lainey. Now, I'm just going to hold there before I go to Rosemary. So Lainey does have a few of her books here with her today as well. So if anyone is actually interested in picking up one of those books, she'd be happy to sell you one at cost after the session when you can
I'm supposed to say
have
that
a
at the end.
further
People
chat
don't
with
even
her.
know me yet.
I'm getting out there now because hopefully by the time we get to the end of this, people will just be having a mad dash up to the stage to want to grab a book off you. So just getting that there before I forget as well.
Thank you.
Now, thank you very much, Lainey. Rosemary, I'm going to pass across to you.
Thank you, Stuart. I'm the current Interim Director of the Disability Innovation Institute at the University of New South Wales. So in lots of respects, I'm focused on the future. I'm not focused so much on what we have in terms of technology now, but I'm focused on what the technology will be that is coming. And the reason I'm focused on that is because the Institute and the Institute's role at the university is to ensure that disability is part of that research paradigm, that the research that is being done for what's to come is inclusive and accessible. That doesn't mean that I don't have a focus on what is happening now. I'm a human rights lawyer. I have other hats. I'm the chairperson of the Australian Centre for Disability Law, and as of January, I will be a member of the UN Committee on the Rights of Persons with Disabilities. So yes, I do have a focus on what's happening now and where our policies, our programs, and our legislation is effective and not effective in ensuring access to digital technology. But for me, I think one of the really important bits is ensuring that our student bodies are given the skills from the word go to understand human diversity in its broadest sense. And so when researchers are doing research, they include people with disability and the concepts around disability in that framework of thinking. And so what their research comes up with, what that then leads into in terms of design and production, and ultimately something, a widget of some description, is inclusive and recognises the full continuum of the human condition. And so accessibility doesn't become something that's secondary, that's add-on, that's other. It becomes an integral part of.
We've been doing this for a while. And because we've been doing this for a while, there's been some pretty good milestones we've had over the years. Can you maybe give us, from your perspective, what do you think some of the big milestones we've had over the last several or longer years towards achieving this goal of a more inclusive society?
Thank you, Stuart. One of the big milestones is that we are celebrating, or rather recognising, the 25th anniversary of the Disability Discrimination Act here in Australia. For the first time, 25 years ago, people with disability had a uniform national law which was designed to ensure that they were able to access things in the community that other people without disabilities, were able to access. So premises, education, employment, nearly most things that we take for granted in everyday life. It's fair to say, I suppose, in the last 25 years, we've seen some progress, mostly around what I would say what people can see, so such as the built environment, accessible transport. What we haven't seen though is a lot or a significant progress around the things that you can't really see, or best just described as abstract or intangible. So we still have a big issue of lack of education for people with disabilities, in particular children, but also relevant for tonight, we're not seeing a great take-up of digital development with people with disabilities in mind. So a milestone certainly is 25 years of the Disability Discrimination Act. Another milestone is the Convention on the Rights of Persons with Disabilities. And for the first time, this was a convention that was developed with people with disabilities as part of the development, and it had them in mind first and foremost at the centre, rather than for people with disability to have to fit in with the environment, it recognised that the environment needed to accommodate their needs. So, for example, people with disabilities accessing education in a way that best meets their needs. So you can see some of these milestones. That said, another milestone is a recognition through the National Disability Insurance Scheme that we need a person-centred approach to ensuring that people with disability can live independent lives in the community. That all said, as I said, we still have a long way to go for our government and for our service providers and companies to recognise that if you don't include people with disabilities at the beginning of the design process, we will have many challenges.
Thank you for that, Alastair. I'm going to jump to Rosemary. So Alastair obviously touched on a few there from the Australian perspective. Any additional ones that you could add to that or think of from a milestone perspective for you as well?
Well, I mean, obviously, but I won't jump on Lainey's parade. But the ADA had a significant global influence, though in a very, Western kind of way, I should say. But
she rolls her eyes.
The ADA was, definitely the blueprint for our Disability Discrimination Act. It had a huge influence on the EU directive back in 2000, the Equality Directive back in 2000. So it influenced, it influenced a lot of the Disability Discrimination Acts. The UK Act was heavily influenced by the Americans, by the US. The Irish were more sensible and they went with our construction of their DDA. And all of those acts have had their problems. The ADA got itself caught up in its definition of disability to the point where, so much of the litigation was about whether a person was a person with a disability under the terms of the Act. That also caused problems in the UK. The EU, their directive was only around employment. So there are milestones, but there's also been, we've taken steps forwards, but those steps have been disabled in some way. I think the EU signing up to the convention is a significant milestone. Though how stable the EU is raises another question, but it still gives a very strong framework for which that to operate in many countries, for the convention to have much more power in many countries because of the European Court of Human Rights. So there are other milestones that you could probably point to in terms of human rights that are very similar to the EU but haven't got the same strength. So the African Charter, the American, the Inter-American Charter of Human Rights, the Marrakesh Treaty. The Marrakesh Treaty doesn't give you anything that the CRP doesn't give you apart from multilateral engagement. But you can't diss multilateral engagement. Government to government engagement can be a strong driving force for change. But you must remember that the Marrakesh Treaty really doesn't give anything that the CRPD gives. So yes, there are milestones, but it's how we implement those milestones that are important. The framework is definitely there, but as we see with our own DDA, it's actually quite a good piece of legislation. I wouldn't have constructed it with a comparator. I would have kept to the RDA framework. But other than that, it's a very strong piece of legislation. The problem is the judiciary has been very narrow in trying to enforce a distinction between direct discrimination and indirect discrimination, and they've been highly, highly technical in their judgments as opposed to being broad and purposive. And any lawyer in the room will know that beneficial legislation should be interpreted as broad and purposive.
Now, Lainey, you've got us coming from an American perspective. Obviously, Rosemary's touched on a few of that. I guess from that view of the American perspective and the history of the US side of things, is there anything else to maybe add to that? Or from your perspective, your thoughts?
Well, one thought is this whole question of milestone. And it's easy to talk about laws, but for every milestone, I'll mention a few more, it's activism and organizing in the disability community that led to the milestones. So like we talked about the ADA, as you know, disability community was fighting for the ADA for over a decade. And before the ADA, we have this law called Section 504, which has to do with the government, the federal government, spending money, and disability community had the biggest takeover of a federal building for 30 days in 1977 to get those regulations, which really, when you talk about framework, you know, the framework is very strong. It's about participation and inclusion, and the courts now are saying, it's not ideal, we'll talk about it later, but that the ADA, which was, you know, signed in 1990, covers websites and covers mobile. So I think when we talk about milestones, we have to remember the day-to-day advocacy work that many of you in the room are probably doing that will lead to the next milestones. In terms of digital specifically in the US, I and my clients negotiated the first web accessibility agreement in the US in 2000. So that's like 18 years ago. That was with one of our largest banks, Bank of America. And again, you know, it's I get the credit, oh, I was the lawyer, it's structured negotiation. That never would have happened if there weren't blind early adopters saying, I mean, I remember the call saying, we were working on talking ATMs, and one of the blind clients called me and said, you know, there's this thing, online banking, and if we don't make that accessible, there was a time before online banking. Or in 2008, when Apple opened its App Store for the iPhone, blind community was right on it. Like, there's a thing called apps. We need to make that accessible. So those are some of the other milestones. We have some court milestones. In 2008, there was the first judge who said websites should be accessible. Last year, we had the first trial that said websites should be accessible. But again, like Rosemary said, the law is so technical. Like, we need a strong foundation, but technology and accessibility has such a potential for creativity and inclusion. And the law is, like, we're all talking about AI and VR and all this stuff, and the law is still talking about web pages and whether there's a connection to a business. So we need the law, we need the strong foundation, we need the milestones, but we have to do the work on the ground to make sure we keep up with the technology.
Thanks for that. Now, I'm conscious of time. We've probably got about another 10 minutes amongst ourselves before we throw it open to the audience. But with that in mind, Alastair, with maybe just a couple minutes, some of these points that are flagged do come back to where we're at today in the sense of the legal sort of landscape and what's happening currently in Australia. Can you maybe give a bit of a picture on that? Because my impression is that we're not a very litigious society, but there's obviously stuff happening and stuff that comes to the Australian Human Rights Commission. So could you give us maybe a bit of understanding of what's happening there?
Yes. Firstly, as Rosemary has pointed out, we've had many challenges here in Australia through judges and how they've interpreted the DDA. At the Australian Human Rights Commission, we run a complaints process where people can complain if they feel that they have been discriminated against under a various forms of discrimination, including disability. The challenge with the complaint process or the conciliation process is that it relies on the individual, so the individual with disability to bring a complaint, and often they are met with a wall of resistance through the respondent. So we try to conciliate it, a non-legal process in the sense that we say this is the law, and we try to get the party to come to an agreement on how the particular situation will fit under the law. And we often strive, where possible, for practical solutions. Some of the complaints that we've had about technology over the years have related to ATM not being accessible. We still get many complaints about websites not being accessible. And it's really interesting to note the number of government departments that are respondent, both Commonwealth and state and territory, to complaints about inaccessible websites. So we've still got a long way to go, as I indicated earlier. And so the challenge is to ensure that we have a system in Australia where my role is to focus on the systemic issues and try and get outcomes there. And we shouldn't have to just rely on a system where it's based on the individual to have to raise complaints. As Lainey has also pointed out, there's been a great deal of advocacy in the States, and we've had that too in Australia. Some fantastic milestones of where the disability community has worked very hard together to achieve outcomes such as advocating for the National Disability Insurance Scheme. The blind community in particular have been very active, very late recently on exactly the issue that we are talking about here today in terms of accessible technology.
Thank you. Now, I'm going to jump to Lainey. Usually I'd let you guys jump in a little bit, and if you really want to jump in, I'll come to you in a second. But Lainey, we've got a slightly different scenario seeming to happen in the United States at present over the last few years. So can you paint us a bit of the picture of what's going on in the United States at present from a legal perspective?
Yeah, one thing I meant to say before, my work has all been with the blind community, and the blind community were the main activists around digital initially. Now, as more technology, video, we have the deaf community being involved in the lawsuits around Netflix captioning for students. I mean, so much of the educational space is now video, so you're seeing more deaf people. And we haven't seen so much legally on the cognitive side, but I think that's going to be next, because that's a huge and growing area, and the activism around people with learning disabilities or people who are autistic, there's a lot of digital issues around that too. So even though I tend to talk about blindness, because that's my personal work, it's really important when you think of what's happening in the US, it's not just that disability. So yeah, in the US, like I said, I did the first, with my clients and my colleagues, we did a web accessibility agreement in 2000. And there were lawsuits filed. Like I said, I do structured negotiations. We don't have to file lawsuits. We have a process that really invites people to sit around the table and find solution. But there's also been lawsuits like the one against Netflix that the National Association of the Deaf did, or National Federation of the Blind has done a lot of good lawsuits in the educational space. And so we were all very collaborative, and it was all very nice. Some people did lawsuits. We also had a great Department of Justice under President Obama that was doing a lot of digital work. So comes now, 2018, and we are on track that there will be 2,000 lawsuits filed by the end of the year about web accessibility. 3,000% increase since 2015, approximately. I was going to say, don't quote me, but there's some video cameras here. I guess I'm being quoted. Approximately.
Yeah.
Approximately. And You know, that's because we have some lawyers who, a very tiny handful of lawyers who are not disability rights lawyers, who saw an opportunity based on the foundation that the disability community built. And so we have a lot of potential backlash against that right now. These cases are cases being filed with settlements that are confidential. No one knows what's really happening, quick turnaround. And it's really important, and I have really struggled with this myself personally because, you know, I don't like that kind of use of the strong foundation we have because it generates a fear. And people are starting to do web access, oh, I'm afraid of being sued. And that is not a motivation that will get us where we need to be in terms of having accessibility built in from the core. But it's also very important. You know, there's a lot of metaphors. Don't throw the baby out with the bathwater, or don't let a couple rotten apples spoil the whole basket. So yes, we have a situation now where we have these lawsuits. There's potential backlash, especially with the government as we have now. But yeah, so that is the situation. I really believe in lawsuits because lawsuits are a good tool. I like collaboration when it's possible. And it's really important not to hear, because you may hear, oh my God, so many lawsuits in the US, it's terrible, you got to change the law. No, it's not that. We have to figure out a way that the very tiny percentage of lawyers who are using the law in a non-productive way, we have to figure out that. We can't, I really believe we don't set policy based on the bad actors. We have to set policy based on the good actors and figure out how to deal with the bad actors. Yeah, I will say on all these lawsuits, they are going in the direction of access. It's very narrow because it's like I say, it's just about websites and judges, like you said, Rosemary. You know, there's talk about who's disabled and who isn't. There's like this, we call it a nexus. You know, is the website connected to brick and mortar? There's all that stuff going on, but by and large, the courts are mostly saying that disabled people have a right to go to court and get accessible websites. So it's a situation.
So we've got an interesting sort of difference between, say, what's happening in the United States, what's happening in the Australian space. From the Australian space, we seem to follow a lot of what your general thinking has been as a lawyer. Rosemary, I'm just curious to get your impression about, are we in the right track, or do we need to be doing more for the community moving forward? From an Australian perspective?
Oh, God, yes, we need to be doing more. It's a tricky ask. You're talking about a dynamic space. I mean, you're talking about technology, and if there's one way to describe the space that we're in, it's dynamic. I mean, the pace at which things, with which technology is changing is incredible. And so how do you take something that's standardised and takes years to develop and get agreed to be as fluid as the thought processes of the developers? So how do you work in that space? How do you keep that space focused on making sure it's including everybody? I think there must be a way of doing it, but I can't see it in the short term, unfortunately. And I think that's why I come back to my first point when I talked about my role at the university and what the Institute wants to do, is that there's a long-term game to embed disability in the broader thinking of the community and get designers taught their craft and researchers taught their craft with the whole human condition in mind. And I mean, okay, that's a bit of a cop-out saying it can only be addressed in the future. There are things that we can do now. But I think litigation is a very small part of the game. I think engagement, one of the best things the Australian Human Rights Commission achieved in the space around the DDA was the original banking standards. And that was engagement with the banks in a positive way about a narrow area that they understood. And so that engagement, the Commission gave space to people with disability and the banking industry to engage one-on-one and find solutions. Now, the longer that process, so once that was established and those standards were in place, that was fine. But as technology changed, those standards became redundant. So that engagement needs to be ongoing. There needs to be mechanisms that we can build into the industries to ensure they have internal watchdogs. And this is why education of people with disability is so important. We need people with disability, in education, getting the academic, education that everybody else gets, being offered the same academic opportunities as everybody else, so they can be working in these industries and they can be part of the industry and informing the industry about their experience, and so it's not something foreign to them. So engagement is such a powerful thing when it comes to disability, and it's because people with disability have been isolated from the mainstream, and people don't often engage with people with disability, so they don't think of the issues for them. And so it's not willful ignorance, it's just ignorance 9 times out of 10. Yep. And so it's about making space for that engagement and looking at how that engagement can happen in an ongoing, dynamic way.
Thank you for that, Rosemary. And before I throw it open to the crowd, Lainey and Alastair, just any sort of additions to say what Rosemary was saying? Lainey, I'll start with you.
Yeah, the irony is this is a panel on like legislation and law, and we're like lawyers, but the truth is the law really can't be the driver. I mean, it's like we see here in the US, Microsoft is really just doing wonderful things around accessibility because they have made it part of their corporate culture starting.
And why so? Because their head...
I was just finished my sentence.
Satya Nadella, CEO, his son actually has a disability.
No. I was saying I agree with you. And if those of you haven't read the book that the CEO of Microsoft wrote, it's called Hit Refresh, and you can see what happens with one person, and they have Jenny Leigh Fleury, who has the highest accessibility position. And I did a session last year with one of their lawyers, and we saw exactly eye to eye. I've only represented disabled people this part of my career, and they're Microsoft, one of the biggest corporations. And we agreed that, yeah, the law is important, but we had cookies because the law is like the sugar or the butter, but it's not the cookie, it's not the whole cookie. You need the culture and the transparency and the accountability and the design and the development. You need all this. So those of us in the legal space have to kind of humble ourselves with like, how much can we do, and remind people, yeah, this is a civil and a human right, and don't forget that. But accessibility is about people, and the law has its limits.
And
I don't know.
I'll add a little bit to that. Our experience as a consulting firm, a lot of the times it's because our experience is those people who actually have experience with other people with disabilities they tend to be more proactive and towards doing the right thing. Whereas a lot of people, as Rosemary, you were saying, if they've had no experience with someone who has a disability, it's just not in their conscious mind, and they don't think
I
about
should
it.
have, just one last thing on that Microsoft panel. The Microsoft lawyer said, we had 7 things that really make for accessible culture. And number 1 was hiring people with disabilities. That she saw that, and I had never I knew, of course, have to hire disabled people. But she's the Microsoft lawyer, who taught me that is key to digital accessibility. Because if you're designing something and the person next to you is deaf and isn't going to be able to see the video unless you have captions, or is blind and isn't going to be able to use a touchscreen, you're not going to do it. So hiring is, word 1. It's not a separate. I had always thought of it like, diversity hiring, that's important. But no, it's like a critical component.
Which is interesting. I'll throw to Alastair, because Alastair, you flagged earlier of how there were a number of complaints against government agencies, and I do remember seeing a statistic where I think it's over the last 20 years, the employment numbers of people with disability in governments has halved, I think, at the federal level. So we've gone from about 5.8% down to, I think, about 2.6 roughly. So curious, your thoughts, I guess, before we throw it out into the crowd. Anything further to add along those lines?
Certainly, we've seen a decline in the rate of employment of people with disability in the public service, both at Commonwealth and at state and territory levels. Absolutely, in the last 20 years, as you pointed out, it's gone from, I think, 6% down to as low as 1.8%. 2%, and in some ways it's still declining. So we have a significant issue here in Australia of where governments are not employing people with disabilities or giving them the opportunity to come into the workforce and then be supported to become employees. For me, that is also linked to, and as Rosemary pointed out, where we see success is when we bring together the relevant stakeholders, so industry, government, and people with disabilities, and try and identify what is the common issue, and then come up with a meaningful dialogue to develop solutions and to try and work out what where to from here. So absolutely, we are seeing many decline, so the rate of employment, the digital divide that we talked about earlier, and so in many ways we are seeing a backward step. And Rosemary is quite right. We need to always be looking to the future to make sure that we get the foundations right.
Thank you very much for that, Alastair. So I've gone a little bit longer than I was first expecting, but we had some wonderful thoughts and opinions from all 3 of our panelists. What I do want to do is give everyone who may have a question an opportunity to ask a question. We do have some roaming microphones. So, does anyone have a question that they would like to ask? I see a hand over here.
Hi, thanks. That was really to the point, I would say, especially the last part. I had something in mind around asking something towards that. So you kind of answered a bit of what I was wanting to ask. Sorry, you said introduce yourself. So
just a name and then.
My
yes,
name is Brenda Castro. I work as a designer, user experience interaction design mostly. And yeah, my question is basically because in my work I've seen very little people with even minor disabilities engaged in the process. And one of the things that could help us a lot, as designers and in the technology industry, would be to have, for example, initiatives where you could actually, without a lot of resources, access, have the possibility to engage with people with different disabilities on the beginning of your project, which for me, and I'm sure for many other people in my same situation, like in the similar roles, it's just very difficult to approach or to find the people who would actually teach you how to do a better design. Because even if you have the basics, the law or the basics on theory, even web standards, for example, are very clear. Even that is not enough. You need to know people. You need to actually get the people engaged.
Yep.
So are there any initiatives, at least in Australia, that we know that we, people working in the field, could actually access and get that feedback from people who could teach us?
Okay. Now, I'm going to throw to you first, Rosemary, because I think you've got some thoughts to this, and I know there's something in the US she could probably flag.
Yeah, look, I don't know of specific projects, but I know a way you could probably work through it. And I mean, one of the ways that you could do it is by approaching disability organisations. They generally have people that work in this space. If you're respectful to your engagement with those organisations, recognise and respect the expertise that you're seeking, and engage with that as you would any other consultant, I'm sure you would be able to get access to people to be able to support your design process. But this is exactly what we're trying to build into the opportunities for design students art and design students, built environment students, engineering students, is that opportunity to be able to engage people with disability to be involved in their projects from the very beginning, to help frame the questions, to help frame the design parameters, and to be part of the team. But so I think if you go to organisations such as Vision Australia, or even the deaf services around the country, or People with Disability Australia, that they would have people that work in this space and would be quite willing to assist you if you approached it as part of your project.
I'll add one thing to that. So there are a couple market research companies in Australia that will help you find people with disabilities. Our company does something similar as well. What we generally recommend, though, is that if you're going to go down that path, you've got sort of sometimes two options. You can go find volunteers, but we generally recommend that you compensate people for their time for any research. But what I want to do, Lainey, there's also Teach Access in the United States. If we come back to the education side of things, we sort of have two angles here. We've got the angle of including people with disabilities as part of the process, but the education side was another element to that question. And the Teach Access initiative in the United States seems to be trying to deal a little bit with that from the US perspective.
Yeah, I can answer. I was going to say that I know there's some people just right in the room from Digital Gap Initiative, for example, which is a grassroots organization. I think that, and I don't know who else is. Right. Giselle, raise your hand in case anyone wants to talk to you afterwards.
Sorry, Giselle.
Yeah, so a couple things. Yeah, Giselle over here. I keep on my website, and I would recommend someone here do it, of nonprofits, NGOs who do this kind of work. There's also consultants who do it. I think it's really important to treat whatever consultant you bring in or a disabled person as a part of the process, not an add-on. It has to be just like any other vendor. That you have a security issue, you want to make sure you have hit all the buttons on security. You're going to have that built in. It's going to be a part. If disability issues become add-on or second nature, or we'll just do it after work, or we'll just have a volunteer come in, give them a gift card, it's going to get lost once you get to the next phase. We have this thing going on in the US, and it might be even global, Teach Access, where we don't have enough skilled designers and developers who know accessibility. And so the big companies have gotten together, and they have a website. I think it's definitely Teach Access, might be teachaccess.org. And this summer, for example, they brought in 25 computer science students to Silicon Valley, and they spent 3 weeks going around and meeting the big companies, and a lot of the companies have what they call empathy labs, where you can try out the equipment and just get some basic understanding, because we need But that's sort of a Teach Access separate thing. That should have disabled people in it, but somewhat different than the whole usability, making sure disabled people are involved from the outset in the design. But yeah, I really recommend having because we have a lot of NGOs, and there's also people, like people in the US, you can do it remotely. And you can get feedback remotely. I think you guys do that at Intopia and...
Well, there's Nobility, for example, in the United States do a lot of it remotely. They find hit and miss about the potential benefits of that. We do it more locally type stuff, but we're one of a number of organizations that do the same thing. So there are organizations out there that do that. I think if you connect more with the accessibility community, that will give you more opportunities to sort of find these organizations and groups and everything Rosemary and Lainey just said that can help you include it. And just being aware of that's the first big step.
And one quick comment from me on this, when it comes to teaching students about inclusive design, it's important to stress that people with disabilities are very diverse, just like people in the community. So many organisations will bring in a person with a disability, let's say, for example, a blind person, and say, well, we consulted with a blind person on the design of this product and we've ticked the box. Somebody who, for example, is totally blind with no sight, as opposed to somebody with low vision, will have very different needs when it comes to how you use a smart device. So it's a really important point for our students to remember is to always keep that in mind, the diversity of disability.
Even two people with the same blindness about them may have different levels of aptitude for technology, and we see that a lot. So there's a lot of those variables to keep in mind. Conscious of time. And other questions? Sean, over here, just in the middle.
I'm just curious, like currently, if you're a disabled person, you go through the DDA process, there is a fear factor out in the community where people might not want to take up the process, A, too complex, or B, the factor if they lose the case they're going to bring up, they could be countersued for the legal costs. So I would like to know that the pros and cons from the US side of things and from the Australian side of things. Should we have something in there for like a safety net to permit people to utilise the DDA more often and to get that social change we're all trying to achieve?
Who wants to jump in first? Alastair?
Thank you, Sean, for that. Look, in terms of what we try to do at the Australian Human Rights Commission with the complaint process, as I said earlier, we encourage the parties to come up with the solution that is the best outcome for both the complainant and the respondent. I acknowledge, of course, the barriers to that are, people with disabilities feeling intimidated or overwhelmed by the system, particularly if the outcome is not what they want and they wish to take it to court. They have the option of taking it to court. However, as many of us know, the justice system is very expensive, very complex, very time-consuming, so many barriers. So all up, for me, it's really important for the Australian Human Rights Commission to promote the outcome where we can, noting that the outcomes of conciliation are confidential, but where we can, we try and promote. For example, if an employer agreed to do things like disability awareness training or to implement a more proactive, inclusive design process and so forth. So we try and do that. So that's just some of the pros. Of course, some of the cons are being overwhelmed by the system.
Rosemary?
Beyond conciliation, we don't have a human rights jurisdiction within the federal court. So we don't have a human rights jurisdiction that is a no-cost jurisdiction, and that is problematic. I believe there is probably a good case for a human rights jurisdiction that is a no-cost jurisdiction, because the cost issue is a big issue. I mean, the decision to take an unsuccessful conciliation to the federal court is definitely a difficult decision to make for people. Do my kids go to the local high school with their siblings, or do we lose the house? I mean, not a question you really want to put on people. The other issue is that we've got jurisprudence where business cases have with very little evidence, and I mean, not a particularly well run case, but unfortunately a very adverse decision in terms of Jetstar and King. And so when you see business cases trumping beneficial legislation, it's very difficult to inspire confidence. So the cost jurisdiction is a problem, and there are mechanisms like cost capping and stuff like that, but there isn't enough. I mean, there would need to be a wholesale recognition of a no-cost jurisdiction before we got any change. So I don't see that on the horizon anytime soon, unlike the States.
Well, one thing you just, Alastair, you were talking about confidentiality, and that would be a place that would be good to change, because my clients and I have really insisted on transparency of our agreements from the beginning, because nobody wants to go first. And even though I never go to court and we don't have any court cases, we have what I call industry precedent. So when we convince the first bank to do talking ATMs, the next bank could say, oh, well, they did talking ATMs, I won't be first. Talking prescription labels, it was a big issue because nobody had them. There haven't been any court cases. All the pharmacies have done them as a result of structured negotiations. No one wanted to go first. So we do tend to keep the money part of our cases confidential, like what attorney's fees are paid, I'll mention that in a minute, or damages to the client. But I think it's really important, and that was one of Microsoft's elements of the cookie, transparency, and say what you're doing, not just so people can have the benefit, because if you're doing accessibility but nobody knows it, that's a problem in itself, but that so other businesses can have the benefit that they're not the first, and there can be learnings, even in a competitive field, that there can be learnings from each other. The way the money works in the US is that the Americans with Disabilities Act does say that if you win your case, the company or the government that loses has to pay your attorney's fees. And that works even in settlements, so that is my business model, I guess you'd say, is that when we settle with a company, they do pay our attorney's fees. And the idea that, and this is how we never have any issue, because we say, and this is true for race cases and gender cases, that the people being discriminated against don't have the resources to hire a lawyer. So if you win your case or you're successfully settled, you do get your lawyers paid. And you only have to pay the company if your case was frivolous. It's a higher standard. If your lawsuit was frivolous and unreasonable and without foundation, something like that, those kinds of words, then you might have to pay. Vexatious, right. Then you might have to pay. But it's not like, oh, if you lose, you're stuck paying. And the attorney's fees, I think, is a really big piece of it, because we have a separate law for airline access. Airlines aren't covered by the Americans with Disabilities Act. That law doesn't have the attorney's fees piece. And so that law has very little enforcement. People still, in 2018, the terrible problems with wheelchairs getting wrecked and people not being treated fairly. So the attorney's fees piece is an important part.
Yeah, don't fly in the States. Not an American airline. Believe me.
Yeah,
Yeah.
that's a problem.
Our co-founder is a wheelchair user as well, and he's had a few issues as well from flying,
Yeah,
unfortunately.
because you can't sue them, because there's not that independent. They call it you have to go to the administrative processes. You can't go right to court. So
Okay, we probably have time for one more question. We've had gentlemen jump in really quickly down here.
Hi, my name is Clive. We're currently setting up a startup to enable carpooling services for the disabled carers and guardians. So carpooling in its traditional sense, where one parent or a guardian or a carer could actually help another parent's disabled kid or child. One of the things that, and it's not a service that we're going to charge by the hour to the parent. It's going to be a business-to-business model. So, it's just a subscription fee that the business pays, and then the users can use it for free. But the challenge that I have is, how can I actually train up able parents to help other parents who have disabled kids, just so that they can look after the person when they're transporting them from point A to point B. So my question is, are there any organizations or training frameworks in place to kind of at least give the basic guidelines to, able-bodied people to help another disabled person?
Who would like to jump in on that question?
Sorry, and it's called Enabler. And
That's
and I'm
Hoi
happy
Hoi
to
Nguyen
provide
down in
by
Melbourne.
Hoi Nguyen. So he won a Maya Foundation grant to develop something like that based on the standards and with avatars to train people in a safe way. It's really quite cool.
When you're saying there's so much happening, like here in Australia, we've got the Remarkable group, and the Remarkable group is part of the Cerebral Palsy Alliance, and they're a startup accelerator to help organizations that are focusing on using technology to target and benefit the disability community, which is a large community. And they're trying to help people to get their startups up and running as an incubator process. So Hoy's company Enabler is one of those groups, and it's some great stuff that's actually happening here in Australia. Alastair, sorry, you were going to jump in.
Firstly, Clive, it's fantastic to hear that you're being so proactive in terms of using technology to address what I think is a very significant need in the community. We've got many families who are with children with disabilities who just want the best for their child to be educated in a mainstream setting, and they have to make many sacrifices to try and achieve that ideal. You could, for example, think about contacting Family Advocacy New South Wales, who do a lot of advocacy about children and inclusive education. So that's just one that popped to my head. And of course, as Rick mentioned earlier, PWD and others who might be able to facilitate some sort of referrals or connect you. I think it's just great. And it's really good to see also all the innovation that's going on in the disability sector at the moment, particularly with the NDIS. And we need to make sure that yourself, Clive, and others have the means to be innovative to make sure that we don't get stuck in the bureaucracy or hamstrung by red tape and government inaction. So my hope for the future is that innovation for people with disability can be allowed to be as innovative as they can be.
So we're pretty well out of time, but what I do want to do is allow a short 1 minute final sort of thought pieces from each of our panelists, from both the questions and we've had through today and the commentary we've had this evening. And what I might do is I'll go from right to left. So Rosemary, I'll actually start with you. I know you were hoping to go last. But I'll start with you, Rosemary, and yes, a short sort of takeaway. What do you think from today? Maybe what do you think we need to do? What would you want to leave everyone with as a thought point?
People with disability have just got to be part of the community. I mean, if engagement is how it works, if we're there and an integral part, then it will work, because we'll be seen, we'll be doing, we'll be part of. I know it's a simplification, but I think, two of the questions that we've had tonight is about how do I contact people with disability? Well, if we were more included in the society, if the society was more inclusive, those questions wouldn't need to be asked.
Thank you, Rosemary. Lainey, what would you like to
That was
leave?
a really good summation.
You can always go ditto, but what else would you like to add?
I want to say ditto. I guess I just want to throw in a word we haven't said, which is intersectionality, which is disability is not its own thing over here. that any conversation about access to justice for poor people, for Indigenous people, gender, disability is cross-cutting. And the more we can take it out of the silo, it's like, you know, another way from what, in addition to what Rosemary said, the better, because we can't just be an add-on. You know, we can't be an afterthought. We have to be there from the beginning. And the more, like you said, we recognize the full scope of humanness, the more we're going to have accessibility. And also, don't forget, we're all going to get old on top of everything else. As a last resort, you know, design for your future self. We are all going to need this. We are all going to need this. Some of us sooner than others. Thank you.
Thank you, Lainey. Alastair?
When I reflect on the cases, for example, as Rosemary's mentioned, King versus Jetstar, and there's been many others such as Graham versus Railcorp, and when I reflect on how the respondents have been very defensive and very adversarial, and when I reflect on the complaints that we get at the Commission, at large organisations, we need to build a culture of inclusion for everyone in the organisation. You can have a fantastic CEO or board saying this is the right thing to do, but if it doesn't trickle down to the frontline staff, to the designers, then we will never achieve an inclusive society. So a culture of inclusion is everyone's responsibility.
I can agree more with that,
Amen.
Alastair. I'm a big fan of a value statement's not enough. It's actually got to be embraced and action throughout the organisation. Alastair, Lainey, Rosemary, thank you all for your time this evening. I know, Lainey, you travelled a lot farther than Alastair and Rosemary.
I got to come to Australia.
But it's been fascinating, it's been enlightening. There's some really interesting points all three of you brought to the table for everyone here. So if we could have a nice round of applause for all three of them. Thank you very much. I also want to thank a few other people. I'd like to thank University of Sydney, University of New South Wales, Telstra, Intopia. I also want to thank the Sydney Web Accessibility Meetup Group and the Accessibility Camp, or Alley Camp and Alley Bites, all of which have worked together to help us put this on for you today. So I really would like to thank all of them, because without them, we wouldn't have been able to put something like this together as well. So thank you very much for that. I also want to thank Meredith and Lynn from University of New South Wales, and also Renata and Chris from Intopia. All four of them have done an amazing amount of effort behind the scenes to make sure this ran hopefully as smoothly as it has. So thank you, each of you, for your time and effort. So finally, thank you all for attending, and thank you for your participation this evening.